I think we've waited long enough. Maybe we'll have some other people show up as we're going along here. But I think we should get started. But yeah, I mean, really, so everyone who is here, my name is Michael. Hi, I am an organizer with a group for Our Future Wisconsin. We advocate for progressive policy change. And a lot of what we talk about sometimes are things like workers' rights, union protections, climate protections, strong public education, etc. We'll talk about that later. What we're talking about tonight, though, is the subject of workers' rights. So your rights as a worker, stuff that's protected under federal law. So it's all 50 states, so it is just the US. But that's what we'll be talking about. If you have any questions while we're going along, please feel free to either put them in the chat or raise your hand, and I'll try to keep an eye on that. And if you want to just ask verbally, you can unmute and do that. But yeah, I will just ask questions as they come to you, and I will, I or someone will address them when we see them. As my guest tonight, joining us, we have Patrick Carlson, who is with the Wisconsin Pipe Trades Union. Do you want to say a little bit, Patrick?
Oh, good evening, everyone. Nice to see you all. Yeah, my name's Patrick Carlson with the Wisconsin Pipe Trades Association. So we're part of the United Association for pipe fitters, steam fitters, plumbers, welders, kind of the gamut goes on. So we cover quite a big area in North America. We represent Canada, Wisconsin, or not Wisconsin, the US, and Ireland, and there's a few other fringe countries overseas too. So all over the place. Yeah, here to answer questions or anything, or even afterwards, if you want to reach out to me, just shoot me a message. I can give you my number and that, but always here to help. So thanks for putting this on too, Michael. Appreciate it.
Awesome. Yeah. Thank you very much, Patrick. And absolutely, this is my pleasure. We also have Nate Rasmussen, who is with the International Brotherhood of Electrical Workers, who just helped our workers here with For Our Future recently unionize. So we just recently ratified our first contract, which is really cool. Nate, thank you for being here. And I know you can't stay super long, but if you want to say hi.
Yeah, hey everyone. Yeah, Nate Rasmussen, IBEW 2304. So we're out of Madison, Wisconsin, and like Michael said, yeah, we just organized the workers there at For Our Future across the country so that's obviously exciting news for our local, our international, and for the workers there too. I do have another commitment at 7 o'clock, but I'll put my contact information in the chat, and if people have specific questions or anything, don't hesitate to reach out to me. We're a little small local here in Madison, Wisconsin, and I don't think that I have all the answers, but I'm happy to talk to anybody and find answers if there's any questions.
And for what it's worth, to that point, Nate and Kim Moon and Sean Reins, who were among the IBEW people who helped with our negotiations and organizing, they don't work in political canvassing and organizing necessarily directly, but they were still more than willing and happy to help us to learn more about what we do and what our work entails, and make sure that stuff got into our contract. For the record, though, I do want to also say before I introduce Jessica, the stuff we're going to be talking about, the federally protected rights that we'll be covering, are not just for union members. So despite the fact that Patrick and Nate are here as union representatives, we're talking about stuff that is for workers who are non-union and union. There's a little bit of stuff that is more specific, but we'll get into that later. So even if you're not part of a union or don't have intentions to join a union or unionize your workplace, there is still you still have federally protected rights. So anyway, sorry. And last but not least, we have Jessica Gibson here with us from the National Labor Relations Board. Jessica?
Yeah, hi everyone. I am a field examiner, which is a fancy name for an investigator, here in Milwaukee, Wisconsin, and I have been an investigator with the agency for almost 17 years.
Nice. That's quite a while. Must be a nice gig then. All right.
And I think I'm the second lowest in seniority in our office. So we have an experienced office.
Great retention.
Most people who have over 20 years experience, and I think our officer in charge is 45 years plus experience.
Private employers could learn a thing or two from you guys. And I talked to before I connected with you, I talked to the main guy in your office. I forget his
name. Mandelman?
That sounds right. Yeah. And he was a delight, but a trip. Before I prattle on too much longer, we can go ahead and get started. The way that I'm going to do this is I have a Google Slides presentation that I'm going to run through. It's super fun. I'll just kind of be talking through the stuff that's on the slides, adding some additional information. Patrick, Nate, Jessica, if you have anything additional that you want to add as we're going through, or if I say something that's incorrect, please jump in. If anyone else has questions as we're going along, again, please ask them. Oh, and now that we have like people here, and I may have to say this again at the end, but I am recording this meeting and I am going to put it places later. So if you don't want to be on video, that's totally fine. I get it. If you do turn your video on, if you end up asking a question or whatever, I will send you a link to our media release form. Otherwise, I guess I'll edit you out. But anyhow, I'm going to go ahead and share my screen. How do I just do the whole thing? There we go. And we're going. Blah, 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 blah. All right. Do you guys see this panel of cameras over here also in addition to the rest of my screen? Because that's obnoxious if so.
No.
Okay, so you guys don't see this panel overlay and stuff. Okay, whatever. So pretty much everything that we're going to be talking about tonight are rights that are protected under the law, the national labor that established the law is the National Labor Relations Act. That law, which was passed in 1935, established the National Labor Relations Board, which is the part that Jessica is here with, and they are in charge of enforcing the provisions that are part of the act. So it established protections for workers, a number of different protections, but collective bargaining was a big one. I won't devolve into a history lesson here, despite my inner nerd. Freedom of association and the right to seek better working conditions and representation. That part I said, okay. Which employers are subject to NLRA oversight or NLRB oversight? It applies to most private sector employees, including manufacturers. Blah, blah, blah. Basically, it covers everyone except government employees, agricultural laborers, and railroad workers. They are exempted specifically from the act and fall under different rules and guidelines and everything like that. We're not really going to be talking about them. We're talking about everyone else. So unless you work for some part of the government, whether that's city, state, local, or federal, city is local, like whatever, or are an agricultural worker. And then Jessica, I have a question for you. This is an odd duck one. Someone asked me the other day, are employees of Cannabis farms classified as agricultural workers?
They can be. We've had some recent cases out in the West Coast involving cannabis workers, and it's very fact specific about whether or not you are an agricultural worker or not. I'd say generally, though, that if you're not deemed an agricultural worker, then we still do cover, despite whatever the federal law says it is. But yes, it's very fact specific. So it's not a one answer that yes, they are, or no, they aren't. It's gone both ways, I believe.
Interesting.
Some have been found agricultural workers and some not.
Thank you. I will take that back to my friend who I don't think it can make it tonight. Because my answer to them was, I'm not sure, but it probably depends.
Yeah, it depends on what they are actually doing. If they're involved more with like the cultivation and the growing, then it's probably more likely that they would be an agricultural worker. But if they're doing more things like packaging, that sort of thing, then they may not be an
So it kind of comes down to their job responsibilities is what it said. Okay, makes sense. All right. That is my curiosity satisfied there. So which employees are protected? Most employees, like I said, in the private sector are covered under the NLRA. Doesn't cover, I said those ones, and there are a few exceptions for supervisors. And last time that I put this event on, someone had a question about that, and I wasn't sure about the answer. But maybe you can speak to that just a little bit more, Jessica, what exceptions there are for supervisors, or when an exception would be made.
Sure. So Section 211 of the National Labor Relations Act specifically identifies what defines what a supervisor is. So if you actually look at the text of the law, it'll tell you someone who has the right to do things like hire, fire, assign work, reward employees, etc. And again, that is always very fact specific. So we can't always say that someone with this certain job title will be a supervisor or will not be a supervisor. So what we do is we do an interview with the person to determine if the employer claims that they're a supervisor and they're not covered by our act, then we do an in-depth interview with the person to determine what their job duties are. It can be very monotonous. We're going through, again, every single one of those indicia, and especially with the right to assign work. Even if you assign work, sometimes you still may not be a supervisor, because then it comes down to whether or not you use independent judgment in that assignment of work. So generally, people who we deem to be what we call Section 211 supervisors are not covered under the National Labor Relations Act. However, there is an exception, two exceptions actually. First, if a supervisor refuses to commit an unfair labor practice under the National Labor Relations Act, and there is some sort of action taken against that supervisor for that refusal, they could file a charge with us, and they would be covered in that situation. So if a manager says, hey, go interrogate those people about what their union activities are, and the supervisor says, I refuse to do it, and they're terminated, that would be an exception, and that supervisor could file a charge with us over their termination. The second exception would be if the supervisor is involved in any way in an NLRB proceeding. So for example, if they are called as a witness and maybe they give testimony that's adverse to the employer during that hearing, and then they are terminated or disciplined for their role in the NLRB proceeding, that would be another exception where they could file a charge with us. But otherwise, besides those two exceptions, supervisors are not covered under the National Labor Relations Act.
Got it. That is a really comprehensive answer. Thank you. I mean, no, but those exceptions are, I think, really important as contextual evidence or contextual knowledge. Whether someone's a supervisor or not, just, I appreciate knowing that personally. So the first kind of section that I'm going to talk about are rights that are protected by the NLRA and NLRB that are not union-centric, mostly because, and I love that I am a union member now. I know, though, that my labor contract with my union gives me a bunch of additional protections outside of the scope of the NLRA. So we're going to start with the non-union stuff. So these are all things that are protected by the NLRA and NLRB. your right to organize and take collective action to improve your workplace. That is a pretty broad definition, and it has a pretty broad scope. Improving your workplace can involve a ton of different stuff. I mean, anything from compensation and benefits to working conditions or unsafe working conditions, unfair labor practices. There's a bunch of stuff that falls under that sort of designation, that if you are organizing and taking action to try to change XYZ things that fall under workplace conditions, that is protected. You also have a right to discuss pay and benefits with other employees. So I have talked to a lot of people and worked at places in the past that encourage you to keep this information private, not to discuss, your salary, not to discuss compensation, not to discuss benefits packages, or some places where they have a policy that outright forbids discussing compensation. Despite the fact that those things exist, the companies that are have those kinds of policies and perpetuate an atmosphere where they discourage discussion of compensation, those are not legal things that they're doing. So even if you, and this is another thing that is, I think, important for people, even if you have an employee handbook where there's a specific thing that says, you will not discuss salary or whatever it says specifically that you signed, it doesn't matter. It's not something that's enforceable, because the policy that you agreed to, the thing that you signed, is asking you to agree to an illegal policy. And so it doesn't matter if you signed an employment contract or a handbook or something like that, where there's a policy that says you're not allowed to discuss salary. Your right is still protected. Your right to organize, collect signatures on a petition or on cards, otherwise take collective action in an attempt to improve your workplace. Again, this is a pretty broad scope. It can include a lot of things, a variety of concerted protected activity. You have a right to collectively refuse to work in unsafe conditions. Your right to discuss workplace problems, either directly with your employer, with a government agency like the NLRB or others. Labor board, state labor board would be another one that would play a role there, depending on what state you're in and what you're talking about, or the media. All this stuff. And one other thing that I wanted to say about your right to discuss pay and benefits is that if your employer allows for conversations that are not directly related to your work in your workplace, so they let you talk with other employees about sports or television or movies or whatever, they also, therefore, if they allow that, they also have to allow you to discuss pay and benefits, organizing, things like that. They can place some reasonable restrictions, which I'll talk about a little more, or we'll ask Jessica to talk about more. But by and large, that is also something that is protected. And for all of this, your employer is also not allowed to discharge, discipline, or otherwise punish you for asserting your rights. So for engaging in these protected concerted activities. I talked a lot about this slide. Before I keep going, Jessica, Patrick, Nate, or anyone else, did you want to add anything, or anyone have questions? All right, I'll keep going.
Sorry, I was just gonna put in there, I slowed on mute. We do a lot of different things with the private sector, as far as looking and reviewing at employee handbooks and things like that. And the biggest takeaway for anybody, union or not, is know your rights and look at that. Actually read the employee handbook. When you're sitting there in a job interview or starting your first job, look through that employee handbook. We have multiple people that bring things to us and we have them cross out stuff. And it doesn't affect their getting the job placement in the first place as far as whether they're going to get hired or not. It lets the employer know that, hey, I can't do this. We have them cross out things and specifically right, and that's against my federal rights as an employee and things like that. So don't be afraid and don't overlook reading those things if you are out there looking for a job or things like that. That's my biggest thing to pass on.
That's great advice. And your associate, Kyle Croft, who joined us for the last time I put this on, he made sure that I was aware of a document called, well, I don't want to try to find it now, but I think it's like 35 things your employer can't do, which I have as a PDF. And if ever, do you have it right there? Yeah. I mean, you can find it if you're interested. You can find it just by Googling it, but also I will put a link to that PDF in the chat at some point here. Okay, Will has a question in the chat. What sort of penalties are assigned to companies that violate the NLRA? How should attempts by management to undermine labor action be dealt with? I will default to you, Jessica.
Sure. So generally we have what we consider a make whole policy in terms of remedies. So if someone is terminated and the National Labor Relations Board decides that they were unlawfully terminated due to either their protected concerted activities or their union activities, we seek to make that person whole. So that would be reinstatement to their former position, and then any back pay, but it's actually then back pay minus interim earnings. So if the employee would have earned, let's say, $10,000 during the period of time in which they were not working for the employer, but they earned $5,000 at another job, then the only amount that the employer would be required to pay them would be the difference between those two amounts, the $5,000. So the idea was to not give a windfall to the employee. Sometimes, though, employees do not want to go back to work. At that point, we can negotiate what we call front pay, which is essentially a dollar amount that they get in exchange for waiving their right to reinstatement. And so that the idea is that money is essentially supposed to tide them over until that they can find a new job. But with a discipline, the remedy would be to remove the discipline from their record. For all violations, we require the posting of a notice to inform employees of their rights. It gives assurances from the employer that they won't engage in that specific conduct and what the employer is going to do to remedy it. We do not have any penalties. If you've been following the news lately, there's been an attempt by the Democrats to include language that would give the National Labor Relations Board the chance to impose financial penalties, but
Some teeth.
Some teeth, as people would say, but that has not passed. So as of right now, we do not have any penalties that we can slap on an employer or a union for any type of violations. Instead, if it's involving some sort of monetary thing, it's just make whole. We do have situations, I won't go into, bore you all with details, but we deal with the relationship between unions and employers as well. Sometimes there will be an allegation that an employer has made a unilateral change without negotiating with the union. Again, sometimes there might be some sort of monetary component, like they didn't give employees a raise or something like that. Again, but the idea is make whole and not providing a windfall and no financial penalties.
Yeah. And I, on my own, looked into a while ago because I was kind of wondering the same thing, you know, because you see, like, I've worked for companies that have policies that forbid discussing salary, which is a violation. And I was like, I wondered, what is the penalty? And looked into it, and there are like some very specific circumstances, but in it where there might be some penalty that an employer would face, but it wouldn't be from the NLRB directly. It would be a specific case where like a judge found them in contempt or some other thing like that. But that would be not, it would not be a penalty levied by the NLRB.
Right.
Okay.
And we, I mean, the workforce is changing. So in the past, it just used to be that people had to post this 8.5 by 14 notice. But now with you know, intranets and email, any way that an employer, or again, we do have unfair labor practices against unions, so I shouldn't just say employers, but a charged party. Any way they communicate with people is how then we want that notice to be communicated to employees. So if they have an intranet, we make them post it there. If they email people, we have them email it there. I even had a case where they routinely texted with employees, and so we made them text a copy of the notice. And sometimes we can do things, we can negotiate in settlement agreements, like a notice reading. If the conduct was really egregious, we can work into the settlement an agreement that the employer will read the notice out loud to a group of employees. Or sometimes we have it where one of us will go to the facility and read it with the manager standing next to us. And then we're also doing some other things under this current general counsel of making sure, again, if someone loses their job, let's say, and they have their car repossessed, the fees along that deal with that repossession, we're seeking those in settlement as well, because we're trying to make the person completely whole. So
Sure.
late charges on their credit cards because they were not able to, if there were fees, if they had to take out money out of their 401k, any of those type of expenses that an employee incurred, we would be seeking those in settlement.
That's super, again, super useful information. That kind of answers a question that someone had the last time I put this event on. Because I did my best to describe like the make whole kind of thing, but you added a ton of detail. So thank you so much. That is a great addition. Did anybody else have any questions before I go on, or anything they wanted to add? Oh, one thing that I did want to say, since we're kind of tacking some advice on here. No, what I was gonna say, sorry, is that if you have reason to think that you may encounter a labor violation or are witnessing some sort of violation of your rights, try to get everything on record. So keep like emails, keep text messages, keep internal memos that lay out something that you think is not great or maybe is illegal. If you try, Wisconsin specifically is a one-party consent state for recording. So you don't need, you can record a phone call or you can record on video, you know, a meeting or something like that without getting permission from the other party. I notified you all out of courtesy, not because I was legally mandated to, but keep records, record things like you've been watching the news lately, Starbucks in their union busting joy. There was the recent incident where the workers at a Starbucks location came to management to present their demands, read their demands, shared them with management, and said they weren't going to leave until they got some kind of assurances or response. There was a phone call, and then the manager left. And there wasn't really a great resolution. Turns out that the manager had reported them for like kidnapping and several other things. Thankfully, somebody was recording the whole thing and then posted that, at least the audio of it, online, and where you can clearly tell that they were not kidnapping anyone or keeping the manager there against their will. If they didn't have that recording, you know, who knows how that might have gone. So just, it's in your best interest to keep records of things, keep evidence of stuff, record things, you know, if you have to, or request that people put stuff in writing. Yeah, that's pretty much, yeah. Unless anyone else has anything else to add, I will keep going. All right. So union organizing rights that are protected by the NLRA. So union-centric things. You have a right to form, join, or assist a union. You have a right to discuss the union or joining the union or union membership or the, encouraging, trying to convince someone to sign a petition or a union card or to vote for either to unionize or vote for a contract or something like that. Your right to distribute union literature, buttons, shirts, or other swag. That is my language, not the NLRB's, but it sounds about right. Your right to solicit coworkers to sign union cards or a union petition. And pretty much all of this stuff, and Jessica, correct me if I'm wrong, but most of this falls under sort of the same guidelines as your right to discuss salary and other forms of compensation like benefits, where if your employer allows you to have other non-workplace or non-work related discussions on the premises, like on your lunch or on break or, in passing, whatever, they have to allow you to talk about the union. There can be some restrictions on stuff like that, like not to use internal formal communications channels or like distributing union literature. Jessica, I think they can like ask people not to do it in the parking lot, or stuff like that. But by and large, the rights are weighted towards the workers in this case and their rights to do these things.
Yeah, and let me just correct you on that. So
Yeah,
when it
please.
comes to solicitation, so solicitation is if you're going around trying to get people to sign cards or to sign a petition. An employer can prohibit solicitation during work hours in work areas, but they cannot prohibit you from doing solicitation in non-work areas, which would include a parking lot or a break room.
So I had it backwards.
On non-work time. So, on your lunch hour or before or after work, that type of thing.
Okay, perfect. Thank you. Does anyone have any questions on this one? The other thing is that I should kind of cover, because I don't think I really talk about it, but I should talk about it at least briefly. For any of you who are not currently part of a union, but are interested in either joining a union or unionizing and organizing your workplace, or your next job, or just want to know more kind of about that process, very briefly, and Jessica, again, please correct me if I'm wrong, but initially, in order to, you need a 30% yes vote by from the workers to hold a vote on, like an actual vote on unionizing. Then in order for those workers then to form a union successfully, they need a majority vote.
Yes, so in order to file a petition with the National Labor Relations Board, you need 30% of the bargaining unit, and the bargaining unit means the people who would be covered by the union. So you need 30% of those people to either sign union authorization cards if they're trying to seek getting a union, or to sign a decertification petition if they're trying to get a union. But you need 30% of people to make those signatures just to file a petition with us. Then when we actually hold an election, though, the union has to win. It's 50% plus one, essentially. So if it's a tie, if the vote is 10-10, the union would not win that because it has to be a true majority. So it would be 50% plus one.
They should just make you the tiebreaker, like the vice president. And the bargaining unit, how that's defined is up to kind of the people who are organizing it, if I'm correct. So that could be, the workers at a specific Starbucks, or it could be like, if you're talking about a warehouse, it could be everyone on the floor, or it could be like just the people who are doing the picking or just shipping and receiving, or different segments. It doesn't have to be a whole workforce.
Yes and no.
Yes
So,
and no? Okay.
Yes and no. So typically then, and I'm sure Patrick can speak more to this as well, but when a union is organizing a place, usually they have an idea of which type of workers that they're trying to represent. And when
Okay.
the union files a petition, they list out the job classifications that they're seeking to represent. Now, sometimes once the petition comes to the NLRB, we send a copy to the employer. The employer will say this is not an appropriate bargaining unit because either some additional classifications should be included because they share what we call community of interest with these people, or maybe we think this classification that the union petitioned for should not be included for some reason. Maybe they're like confidential employees or something along those lines. So how we actually get to who is in the bargain unit or what classifications are with the NLRB working with the union and the employer to get to an agreement about what that unit's going to be. If the parties are not able to voluntarily come to an agreement on which classifications are going to be in the bargaining unit, then typically we will hold a hearing to determine which classifications should or should not be, and based again on the objections of the employer.
Okay. That's excellent context. Thank you. Will has a more specific question. Will says, I work in a restaurant. Would it be possible? I get it. Are you sub to Kitchen Confidential too? Sorry, Will says, I work in a restaurant. Would it be possible to just have the kitchen unionized and exclude the front of house?
So I always say that I can't give anyone a black or white or a yes or no answer because everything is very dependent. So again, what we would have to look at is whether or not the people in the kitchen share any type of community interest with the people at the front of the house. So we look at things like schedules, supervisors, pay, uniforms, all those sorts of things to determine whether or not these employees share a community of interest or they're really two separate groups. We look at whether or not there's any back and forth between the two groups. So is anyone from the front of the house ever going and filling in the kitchen or vice versa? If they did, that might be indicative that they're not two separate and distinct units. But the law on this also changes all the time. So it's hard to say under this current NLR. So just to let you know too, the NLRB is separated into two houses, so to speak. We have the general counsel side, which is all the field offices were the ones doing the investigations. And then there's the board, which is a 5-person kind of quasi-judicial group that sits in DC and they hear appeals of cases and their decisions essentially become case law. And so under this current board, it may be possible that they would say you could have these micro units because that under the Obama board, that was allowed, and then that was repealed under the Trump board. So the case law on that moves back and forth. So all that to say, maybe. Tough to say.
All right. Well, hey, there you go. There was something else that I wanted to say, and now I can't remember what it was. It probably wasn't that important. Oh, crap. I'm not sure. Anyway, and Jessica, I added this slide since I sent you the link to the presentation. So if there's anything that you see that is wrong right off the bat, just please tell me. I made sure Jessica fact checked me on my presentation since I pulled pretty much everything from their website, and I wanted to make sure I translated it accurately.
Yeah, I mean, strikes and picketing, and again, Patrick, I'm sure knows about this, gets very complicated. It depends on what the intent of it is, because
I tried to be as vague as I possibly could.
Area standards picketing is very different than an unfair labor practice strike, which is different than an economic strike. But yes, you are correct that all employees have the right to participate in them. Again, there's always some nuances of secondary boycotts and everything too, but Just kind of glancing on this, I think it's probably accurate. But yes,
I
it
tried to
depends.
throw in a lot of
Caveats.
CYA here.
Yeah.
So I will just talk kind of briefly on this one, unless Patrick, you want to jump in right away.
No, go ahead. I'll just
Okay.
jump in when you want. So
All
go
right,
ahead.
all right. But yes, all employees, whether you belong to a union or not, have the right to participate in strikes, pickets, protests, concerning work-related issues under specific conditions. It's actually kind of simpler, it seems to me, from looking at the website. If you're not in a union, what's considered protected? Because once you, and that's only because unions have labor contracts with their employers, which will oftentimes have like no strike clauses, or certain periods where the labor contract prohibits striking. You know, if it's something that is seasonal, like if I had to guess, I would probably have to go read my contract. But if I had to guess, I would bet that I am prohibited from striking right before the election. So there can be stuff like that in labor contracts. So it becomes more complicated when you're allowed to do certain stuff if you're part of a union. That's not to say that that means it's a bad thing to be part of a union, because they have a lot more bargaining power. But not just any strike is protected, and the protected status depends on several things. The purpose, or, you know, the target of the strike, you know, what it is about, what it is protesting, or, you know, why are you on strike? The timing, and the conduct of participants. So, for example, if picketing turned violent, or involved vandalism, that kind of thing, then it wouldn't be protected. Correct, Jessica? Okay. Strikes fall into several categories, like Jessica mentioned. In economic strike and a unfair labor practices strike are different categories, and they have different rules. And economic strike would be stuff like pay and benefits. So if you're, you know, protesting to get a pay increase, and that's the primary aim of your protest, strike, or picket, that would be an economic strike or action. Whereas if it's an unfair labor practice, that is the primary aim of your action, that is a different category. This is a built-in link, but I can put it in if anyone wants it. Well, actually, I can just do this right now. I'm just going to do it anyway without anyone asking. There's the link that has actually more information on the NLRB's website. So if you need that, or you can just go, it's nlrb.gov. It's not like it's hard to find. Strikes, pickets, and protests, when protected, fall under concerted protected activity and are protected by the NLRB under the NLRA. And that's all I was going to say. So Jessica or Patrick, if either of you wanted to add anything, please do. Or if anyone has questions.
Yeah, I think one of the biggest things with strike is the concept sounds simple, but they are a very complex animal. And, you know, depending on what type of strike it is, where it's located, the people, are you basically protesting a supplier? Are you doing that? I mean, there's so many working parts to it. Even us that do this all the time, we still consult the lawyer and all these other fun things too, to make sure everything is kosher, and we're, you know, make sure we're in the right path and doing everything correctly. So my point behind it is it's a simple idea, but it's very complex. And if you ever look at wanting to do a strike in the future, I always urge you to reach out to a legal professional or a union, you know, organizer, or someone in that capacity that can help you walk along that and make sure that you have your ducks in a row to make sure that you are protected. Because simple screw ups of just like filming on a picket line can be can be illegal and different things like that. So you just have to make sure that everything is very in line, and it's very complicated, but yet it still can be done. You just have to have the right team put together.
No, that's great. Great to know. And yeah, I was also going to encourage, if you're considering or thinking about engaging in like pretty much anything, any of the stuff that we're talking about, the asserting your rights under the National Labor Relations Act. So if there's something in your workplace that you would like to protest, or if you have intentions to unionize, or if you think that your workplace is violating your rights as a worker, any of that stuff, I would encourage people to contact, like Patrick said, either a union organizer or a union, local union. And like Patrick, for example, I have never met Patrick before in real life. This is the first time I've seen him. I was put in touch with him because I have a friend who I know is a member of a union. I texted him to ask if he knew anyone. He said to call the local, so I did that. And then the person I spoke to there transferred me to the head of the local, who then put me in touch with Kyle, and then Kyle put me in touch with Pat. But like, people are happy to help. You can just look up a different union branch, like a local union in your area, and just call their office or pop in. By and large, there's a lot of solidarity, amongst unions and amongst workers. And a lot of unions will be happy to advise you, to come to an event or speak to, other workers in your workplace. Although, if you keep it virtual, then they don't have to actually show up, which is more convenient. And then you can also call the National Labor Relations Board offices. You can contact them. They have field offices. There's I think, Jessica, if I remember, there's the Milwaukee office that is actually covering also Minnesota. I don't know, but you can look on their website and find an office near you, and you don't have to go there. You can just call or email. I spoke with someone in the Milwaukee office, and they were excited as could be that I wanted to talk to them. That's their job to help workers. And make sure that your rights are protected. So they are happy to advise.
Yeah, we have offices in almost every major metropolitan area. The website, you can put in, look at a map and find your closest office. But every day in every single office, there is someone who is the information officer of the day who is answering phone calls. So you can call any NLRB agent or any NLRB office Monday through Friday and talk to a person who can answer questions for you. We can't give you legal advice, but we can at least try to inform you of what your rights are.
And whoever I spoke to was very nice. Will had a question. Is it legal for other workplaces or other workforces within the same union local to strike in solidarity with another workplace?
Oof.
And I think the answer is
it depends.
It depends.
The biggest, sympathy strikes are what a lot of people, call those under, where you have another group going on strike. So let's just say the electrical workers go on strike. Well, the pipe fitters are on the same project, and we want to support, all brothers and sisters within the union. So we would want to go on strike, but we have to put the brakes on, because depending on what contract we're under, a national agreement, those types of things, we can't do sympathy strikes. They're basically outlawed. So it depends. I mean, it's one of those things, and I'm sure Jessica could really expound on that, but there's most of the time, no, because the sympathy strike clause comes in, and we're kind of not able to do that.
I think it's a little easier if a workplace is not yet unionized. So like, I have definitely seen some protests or picketing. I'm not sure about the technical classification, but I have seen some actions by like Starbucks workers in solidarity with other stores, you know, whether they're in just stores in the same city. And I'm sure it's more complicated than that, but yeah. The upcoming rail strike. So Brittany, that's a really good question. The railroad workers they're under a whole other thing. So they're railroad workers specifically because this is from the 1930s. Railroad workers are specifically exempted from the NLRA. So I don't know nearly enough about the laws that govern railroad workers specifically to answer that. Although from what I know about the situation and why they're planning to strike, it has to do largely with unfair labor practices, overscheduling, understaffing, required forced overtime stuff. But I think they have, again, it's like more complex because there are rail worker unions of different flavors, but it's a whole different batch of laws that apply to them.
Yeah, they're just to let you know, they're covered under the Railway Labor Act, which is administered by the National Mediation Board. I'll put it in the chat, the website for the National Mediation Board. But yeah, their laws are very different. Also, even though it's called the Railway Labor Act, airlines are also covered under that act.
Yeah, that's right. Which is weird, but yeah. Any other questions about this or anything that anyone wanted to add before I keep going? I'll take that as a no, but I can always back up also. So a few things that your employer is not allowed to do. Some examples include spy on union activities or even make it seem like they are. So they can't imply, like, you know, if you say, oh, okay, I gotta go, we have a union meeting, and they say, or I don't know, you're like, I'll tell you about what we talk about later, and they say, oh, you won't need to, in a weird way, like that's implying that they're gonna know already. They can't do that. They cannot coercively or threateningly question you about your union activity or that of your coworkers. So they are not allowed to do that. They also can't bribe you for information on union activities. And that does not just include straight up monetary bribes. So they not only can they not just slip you, well, 20 would not even be worth it. Like, I don't know, a 50, 100, I don't know. How much do you bribe someone with? But they can't do that. They also can't reward you with preferential treatment. So they can't promise you a raise. They can't promise you better hours. They can't they're not allowed to reward you for information in any way, whether it's monetary or preferential treatment. They also cannot fire, discipline, demote, or otherwise penalize you for union activity. And I talked about this also already on this slide, but they also can't prohibit you from discussing unions or distributing union literature during non-work time. And they also, oh, this is another one. Well, this is kind of part of the same thing, but they can't restrict worker communications in a way that is prejudiced against unions. Yeah. Anything to add, or anybody have questions on this?
Yeah, just to point out that all of these items on this slide also apply to when employees are engaged in protected concerted activities. So just going from the basic example of employees are talking to each other about their wages. So again, it would be unlawful for an employer to spy on people for doing that, interrogate them of who did you talk to, what did you ask them about their wages, what did they tell you, those type of things. Again, all those other things, discipline, firing, those all apply to even in non-union situations where employees are engaged in protected concerted activity.
Thank you for clarifying that. Yeah, I lumped it all on one slide for efficiency. How to enforce your rights. So we've already talked a little bit about this, but this has more information. Oh, no problem. Thanks, Max. I'm happy you could be here. Let me know if you have any other questions. You have my information. I know you in real life, assuming you're the same Max. I hope it's the same Max. Sorry. So if the workplace rights of you or others, all right, have been violated, or you think they have been violated, you should contact the NLRB as soon as possible. And within 6 months to avoid any issues with statutes of limitations, which Jessica clarified for me. As soon as possible, as soon as you possibly can. But there are exceptions that can be made that go beyond 6 months, depending. But if you can avoid it, do it with try not
And the exceptions are
let it
very
be 6
rare.
months. Yeah.
Very, very rare. So
So-
definitely contact the NLRB ASAP.
Yes, thank you. To contact the NLRB, you do not need your employer's approval, permission. You don't have to tell your employer. You don't have to notify them or anything. You don't need to be a union member. You don't need a union to help you, although they would be happy to, I'm guessing. And you don't need anyone else besides you and the NLRB to know about it. So like we talked about, you can call their offices, you can, I'm sure they have email or forms on their website. A charge, you have to file a charge for the NLRB to initiate any investigation. But a charge can be filed by anyone with knowledge of the events. The wronged employee or the person whose rights were violated does not need to be the one to file the charges. So it can be someone who's close to the employee, it can be a coworker, it could be a family member, anyone who has knowledge of whatever the incident is, enough knowledge to file the charges, can file those charges.
I would say
Yes.
that is absolutely true. I had a case one time filed by a union rep in New York over an employer in Wisconsin, because I won't say who it is, but he read a news article about their handbook that he thought violated the National Labor Relations Act. And so even though he had no firsthand knowledge, he filed the charge. Now, the problem is there's a hearsay problem, right? So we do need to hear from people who have firsthand knowledge. I mean, that union rep was able to find some people who were able to provide us with testimony. So yes, it is true that anyone can file a charge. But especially if we're talking about a discipline or a termination of someone, we are going to want to talk to that person.
Yeah.
But anytime that we take a sworn statement from someone, it is kept completely confidential. We don't tell the employer or the union or anyone that we took an affidavit from that person. And likewise, when someone calls our office to ask questions of us, that is completely confidential. If someone does file a charge, then the employer is aware, that they filed the charge because their name is on the charge. But otherwise, if someone provides an affidavit to us, so if someone's even a third party neutral witness, that is confidential. There's some cases where maybe later, if we end up getting to a trial and they're called as a witness, that people would learn their identity. But for the most part, their affidavit and the fact that they talk to us is kept confidential.
Thank you. And then this last bit, it's illegal for an employer to retaliate against employees for filing NLRB charges with the NLRB or participating in any NLRB investigations or proceedings. So pretty much all of this stuff also applies to participation in NLRB investigations or proceedings, sounds like. Okay, yeah. So again, all of these things, your employer can't do any of that if you participate with an NLRB investigation. So it's that all that stuff is protected. So enforcing your rights is protected, is one of your rights. Right. Is that the end? I think that's the end. That is the last slide. I wanted to grab a link to this. Okay. Ooh. So just Here is the share link to the PDF that I mentioned, the 35 things that your employer is not allowed to do. So if anybody wants to grab that, that's just, it's in my Google Drive. I just have it set to anyone with the link can view. So if you know anyone who needs it, feel free to share the link. I don't care. But grab that if you want it. Does anyone have any last questions or anything else? Or Patrick, Jessica, any last words you wanted to add? Oh, Will has a question.
Just to let everyone know, I added a link there. If you are going out in the world and spreading the word about workers' rights, the NLRB does have several different flyers, brochures, etc. So I just put a link there. If you want to look at any of those for distribution, you are more than welcome to.
Awesome, thank you. And then Will's question, can a union be dissolved unilaterally by management? No, but they can do, they engage in shenanigans sometimes. The short answer is no. Not notify.
Yep, maybe Patrick has had some
Whoa.
experience with this. I
Oh.
mean, I would say an employer would be doing so at their own peril. Because I presume that the union would then file a charge alleging, that they unilaterally stopped recognizing
Thanks,
the
Evan.
union. They can file a petition. We very rarely get them in the Milwaukee office. It's called an RM petition. Essentially, if management has reason to believe that the union does not have majority support, but generally just, a hunch or something like that is probably not going to be sufficient. But if, for example, a majority of employees delivered a petition to management saying that they no longer wanted the union to represent them, that may be a basis for filing this petition with us. At which point, again, we do the same type of election that we would do to determine whether or not employees want a union in the first place. If they unilaterally do so, again, without filing that petition with us, then they would just be doing so at their own peril.
All right.
Yeah, just to add on,
Yeah.
To the question, the union's going to know, you being a union member within the group, you're going to know if company ABC is hiring 5 people and they're not part of the union, and we're going to know about that, and we take steps to protect that as well. And I've seen some places where they try to hire out of the classification for the union. So let's just say your job description is A and you're part of the union as this A type of job description, this category, and they hire a bunch of B, C, D, and F to try to dilute that population a little bit. It doesn't work in a sense, because that's not part of the not part of the contract or the job classification for that, bargaining unit. So I see where you're going with that question on that, and I have heard of employers trying to do that, but in the end, the union's on top of that stuff. When you become a new hire, that's part of kind of like the onboarding welcome, you get involved in those types of things. So I don't see that happening. I see that more of them just being misinformed and trying to pass that information on to you and not knowing how it works in a sense.
Great. Thank you.
Yeah, and I'm also not sure that a lack of dues paying members would be sufficient evidence of a lack of majority support. So as many people know, I mean, Wisconsin included, there are many right to work states where employees do not have to be members of the union, or they don't. And so in that case, just because someone is not a member may not necessarily be sufficient enough for an employer to claim that there's a lack of majority support. Someone may very well vote for a union in an election, but not be a dues paying member. That they want the union there, they just don't want to pay for it. So I'm not sure that that lack of dues payers would be sufficient enough to claim that there was a lack of majority support.
And for what it's worth, this doesn't necessarily directly pertain to your question, Will, but I did just want to say, so union dues, I know, are something that's often trotted out by people who are fighting against union efforts or unionization or saying they're not needed or they don't provide benefits, which is, as a union member, nonsense. But union dues, for what it's worth, are not like oppressive or like crazy high or anything like that. I forget exactly what I pay every month in union dues, but with the pay increase that my union negotiated for me, even after union dues, I'm taking home more money every month. I'm happy to pay the dues. Actually, technically, because the organization I'm with is our board members are all unions, I'm paid by unions, so I'm kind of paying myself. That's fun. Oh, you know what? Okay, so I was gonna say if anyone has any last questions, but I did just want to say I'm happy that I could put this on. Thank you everyone for being here, both Jessica and Patrick and Nate, though he's gone now, and everyone else who came to learn. I truly appreciate you being here. Like I said up front, am with a group called For Our Future Wisconsin. We're a progressive organization. If you want to be invited to things like this again in the future, I probably will invite you anyway. But if you want to be invited explicitly, I will put my email in the chat, which I should have done earlier. But there's that, or you probably maybe have my information already. But if you want to be invited to stuff like this, please let me know. I'm going to be running this event again next month. Jessica, I know, is going to be there again. So if you learned something, if you enjoyed this, and know anyone else who you think would be interested or think would benefit from this information, send them my way. Otherwise, like I said earlier, also, I recorded this and I'm going to be putting this somewhere that will be available. So if you know anyone who just wanted to watch the recording, let me know about that. I will be done talking now. Thank you everyone for being here. If anyone wants to say last words, please do. Otherwise, good night, everyone. Thank you very much.
Thank you so much, Michael.